The issue of workplace romance occurs all too frequently, and the issue is relatively straightforward. This presumes there is no management document or policy document that sets out what the rules and regulations are with respect to this. If there is not, and the relationship is one between a manager and a subordinate, there'll be a conflict of interest. Clearly, a manager cannot properly supervise an employee with whom he has a romantic relationship and make judgments about raises and performance and matters of that nature. And the manager may well be terminated given that circumstance. The second issue is that involving collegial relationships, that is peer-to-peer, where there is no reporting relationship and the two persons are on the same level. Generally speaking, there is no prohibition against that unless there's some particularly unique circumstance that gives rise to a prejudice or a potential prejudice. But generally speaking, absent a management document that says you can't do that or must disclose it, there's nothing wrong with such relationships. The problem becomes, well, what happens if one person is promoted to a position in which that person will be in a supervisory role over his partner, so to speak, and that becomes more complicated. Then clearly that relationship must be disclosed and it should not continue given the possibility of a reporting relationship. Now, all these things can be, as I say, regulated in a policy manual that the company would be wise to create and make sure everyone knows their rights and responsibilities. The other complication is where the relationship is one of a common law relationship. That is, let's suppose the management document is produced and says, well, you cannot have a peer-to-peer collegial romantic relationship. And one person says, or both of them will say, well, we live in a common law relationship, and that's protected by human rights legislation as a matter of marital status. And it is. Then the company would be in a position where it would have to show there's a genuine business need, a bona fide need to have that policy in place to protect its interest in the workplace. I suspect that would succeed, but it hasn't been determined. But my expectation is the company will be allowed to do that. So in summary to this issue, if it's a superior to a inferior, if I can use that word, boss to subordinate role, the romantic relationship should not be allowed, will not be allowed, and the company can take disciplinary actions, including termination for cause. And secondly, if it's a peer-to-peer relationship, then likely that's something that the company must tolerate, and there's no need to disclose unless there's a visible prejudice or potential prejudice. And the example I gave about one person being promoted to a higher level would indicate that. So if there's any kind of supervisory or potential supervisory role, then it gets conflicted. That's just one example of prejudice. There might be others, but those are the general rules to be aware of. So be smart and be aware.